Welcome back to Land Law Made Simple, where I provide a bit of an introduction into land law and key issues in land law, which are often causing some problems and confusing to students or maybe anyone who's interested in law in general. Maybe some lay persons who are about to buy a house or have some housing issues and are just interested in learning more about land law. In this lesson, we are going to have a look at implied trusts of land. So this is now starting to get a bit more complex and abstract, but I try as always to use as simple language as possible and to really break it down, provide lots of examples so that you should be able to understand how this works by the end of the lesson. So implied trusts, they normally occur when there's more than one person, so a couple of persons, 2, 3, 4, buying a property together. And now the question will be, in whose name the title deeds are now, what's being regulated in the documents, and so on. So if all of the names are in the title deeds and it clearly states how they are owning it, like which shares they have, for example, or whether they all own it together as a whole, that would be an express declaration of trust. Okay, that obviously is a kind of self-explanatory term. The contrast and what an implied trust is if things are a bit more vague, there's no clear definitions, no clear statements in the contracts or title deeds or anything. It's all a bit unclear who owns what. And so in that case, there might still be an implied trust, which arises from conduct, how the people behaved, that kind of thing, rather than anything that's been written down. And there are two main kinds, which are one, the reciting trust, which is probably the easier one of the two to understand, and then we've got constructive trusts, which can be a little bit more complex. Now, a reciting trust, as you can kind of see from the background image I've chosen, they are mainly about issues with money. So, for example, a reciting trust might arise when someone pays part of the purchased property and, okay, their name isn't on any deeds or contracts, but obviously there's still a significant contribution, and that contribution should be recognized because fairness demands that, so equity might step in to protect the person who's been paying something towards the property, even if the name isn't on the legal title and they're not officially the owner. Reciting trusts can still arise to give them a little bit of a benefit, a little bit of support, and the requirements really is just that they made a contribution, a financial contribution, and this contribution wasn't part of a gift or a loan. So obviously if you have a present, maybe you give your son or daughter a flat for their 18th birthday or something like that. If you're a fairly rich family, I guess, that wouldn't be sufficient for a resulting trust. Okay, it needs to be just a kind of outright contribution. And if such a contribution has been made, then equity might say that you own a beneficial share of the property in proportion to what you paid. So, for example, if we have a £100,000 deposit to pay for a property, and you make a contribution towards the property of, let's say, 20,000, then you would get a 20% beneficial share in proportion, obviously, to the whole amount of the deposit. So really just try to remember that this is about money. Just another example to make this really clear. Let's say that Ken buys a house for £260,000, and this is put in his name only. His name is the only one that shows up on the legal title and everything. However, Ken was a bit short. He didn't have all the amount for the deposit. So his friend Barbara, a really generous person apparently, she said, well, that's all right, I help you with the deposit and I give you £26,000, so you can actually buy that house. Okay, now on paper it's very obvious only Ken owns the house, so that's the legal side. And we have it on, like, black on white, written in the title, legal title, that Ken is the owner of the legal title. He's the one who's got all the rights to manage the property, do all the admin stuff, sell the house, and so on. However, because Barbara paid such a significant amount towards the purchase money, she paid all the deposit as 10% of the whole amount, and because of that she will get a 10% beneficial share in equity, just because the courts will recognize it as fair. If she made such a meaningful contribution, £26,000 is quite a meaningful sum there, so she should at least get something in return for that money she paid. Okay, so why Ken holds the legal estate on his own, this is actually now in trust for both himself at 90%, and then for Barbara as well at 10%. Now, constructive trusts, they aren't really about money, or at least that's not the main consideration here. Okay, what constructive trusts are, they are really about fairness. And courts will not just strictly look at which sums have been paid, but they will look at people's conduct, any kind of agreements they have had, the way they behaved all this time. So there's quite a lot of different things that the courts will actually consider, and they need to be really flexible to keep all of those different aspects in mind. Okay, so constructive trusts are really kind of envelope for different considerations. So Lord Bridge, in the case of Lloyds Bank and Rossett, gave two main ways that we can use to find a constructive trust. Okay, so this is the way we use to think about constructive trusts. And his first route, so the first way to find a constructive trust, was based on what he called agreement and detrimental reliance. So what does this even mean? So there needs to be some kind of agreement or understanding that all the parties involved should, for example, live in the property, or maybe should have the proceeds that arise from renting the place, or something like that. This kind of agreement doesn't have to be anything formal, certainly doesn't need to be in a title, in a deed or anything like that. It doesn't have to be a written contract, no signatures, no witnesses, nothing. Even a really informal conversation could be enough, really. And even beyond that, the courts don't even require that this has to be an honest agreement that was really meant by both parties. If, for example, there's a couple and one of them is a bit like, I don't know, selfish, almost narcissistic, so he lies to the partner and says, well, you're able to live in that property with me. I just can't put your name in the title deeds because you're not old enough yet. You need to be 21. But then once you turn 21, we can change that, something like that, just something that's obviously not true. But if the other person then takes this for granted and just trusts that this is correct, then even a lie is not any kind of excuse. The other part that we need then, apart from this kind of agreement or understanding, is that the party was not on the title as such, and was name doesn't appear on any of the contracts and so on, at least relies on this kind of agreement, and this causes them some kind of detriment. So if you already have done modules in contract law, for example, you know this kind of concept where we've got estoppel and this kind of thing. The code kind of protects people to some extent who are relying on a promise. They change their behavior, they adapt to that promise and really trust that the other person is going to keep the promise. And so, yeah, those can get protected to some degree if the other person then says, oh, no, I didn't really mean it, I take it back, sorry. So what kind of detriments would be included? So for example, if you start living in the property and you pay for lots of the renovations that are required, obviously in that case we see a clear detriment because you're using your own money to contribute to improving a property in land that doesn't even have your name on it. Okay. Or for example, if you cover all the bills, so your partner can pay the mortgage, you just divide it that way. One person covers the bills and household and everything, and the other person covers the mortgage. That might makes sense. It's a bit easier to agree on and to decide who pays what. But it's certainly a detrimental reliance because, again, the non-owner agrees to pay some monies out of their own pocket for a property that's not legally theirs. Or another kind of detrimental reliance could, for example, be to work unpaid in the owner's business. I think that's not really common anymore these days. But yeah, you can kind of think of some examples. Maybe you've got someone who's I don't know, doing some gardening work and living on the property while they do that, or they keep the estate. Maybe they've got extensive lawns and so on, so that might still happen. Or you've got a kind of live-in nanny, something like that. I don't know. Now let's have a look at the second route to a constructive trust. And in that case, we actually do have some kind of financial value included, but it's still really focusing on conduct. So we don't need any kind of clear agreement for the second route. Instead, the court will just look at the way both parties have been behaving all the time since they purchased the property or moved in and so on. So if the person who doesn't own the property and whose name isn't on the legal title still makes some kind of other direct financial contributions, like mortgage installments and so on, this would normally suggest that they have a share. So Mr. Rossett, for example, bought a house in his name, and his wife helped with things like decoration and organizing and builders and so on. Now, would you think that this is something that could be protected as a constructive trust or not? So in this case, the court actually said there was no direct contribution, so there was no share that Mrs. Rossett could get, because decorations and organization things, that wasn't really sufficient to count as a direct financial contribution. The only thing that counts then are really substantial things that are direct and necessarily arise from having a property. So for example, the deposit or mortgage installments, those are obviously things that are pretty much necessary to be able to keep up the property. Whereas decoration, that's kind of optional really. And some people might want to spend lots of money on decoration, some people might not, so that's basically their choice. So this isn't really protected then if it's something that's indirect and not strictly necessary really. Whereas things like the mortgage installments, which are really important and are necessary for you to make in order to be able to continue living in the property, for example, those can be protected as constructive trusts. Okay, so as you can see, this is where it gets a bit more difficult to understand, a bit more complex. But we have a look add more examples, so hopefully it will become a bit clearer. So just to keep in mind, for constructive trusts, we have two different routes. One would be the agreement and detrimental reliance route, which I think is still fairly easy to understand. So what's needed? We need a promise about the ownership. So for example, I promise to my partner that they can live in my flat with me for as long as they live, for example. So those words of agreement then trigger a kind of protection in equity, because this is what fairness kind of dictates. And as soon as we can see that the non-owning person has sacrificed something, maybe they've given up their own flat, maybe they have hoped to keep up the property, maybe they have I don't know, made some kind of financial contributions towards the bids, maybe they've helped in the business, something like that. This would kind of mean that we have a constructive trust where those people get a little bit of protection for all their efforts. Now, the tricky thing obviously is that this can be quite difficult to prove. As you might remember, we said that those promises and agreements can be really informal. There doesn't have to be any kind of contract or anything. And that is obviously a bit more difficult to prove. If it was just an informal conversation and you don't have anything on paper. But in theory, it's still possible. I don't know, maybe you've got some witnesses, or maybe it's really clear from the surrounding circumstances, like you giving up your own flat, for example. Now, opposed to that, we've got obviously route 2, where we don't have any kind of promise in the first place. We just need to look at the behavior of the party. So it's not anything not spoken or written. It's just about conduct and contributions. So any kind of direct financial contribution to the property, like purchase money, paying a mortgage, paying the deposit to help out your partner. Okay, so this is really strict, as it just covers any kind of financial payments between spouses, partners, civil partners, and so on. How to remember the two routes? If you're struggling with this, think about those kind of keywords here. For the agreement route, you can remember the 2 P's. So promise and pain. That's the kind of 2 elements we need. A promise or agreement, and then a detrimental reliant, or some kind of I don't know, pain or suffering or sacrifice because of this promise. It doesn't have to be actually hugely detrimental that you're giving up like a big part of your life. It can just be a minor sacrifice. But the pain word just might help you to remember what this is a bit easier. And then for the conduct rate, think about cash that's counting, extra money that's being paid towards the family home, matrimonial home, or something like that. So why do we need those 2 routes? When Lord Bridge came up with those two routes, they were criticised for being really narrow and for ignoring other important things like domestic work, childcare, and so on. Obviously, Lord Bridge did focus quite a bit on money and financial aspects and detrimental reliance. So it's a lot about mortgage and payments and work and so on. But modern day life doesn't only turn around those aspects. It's not really just about promises or cash. There's a lot of things that happen in relationships, and when people live together, it can get really messy. So the law can't just ignore all of those things. If you have a problem question in an exam, it's probably the best way to start with those two routes, and then also analyze any kind of other hints, circumstances that are mentioned in the facts, and then you can use those to broaden the scope and recognize other conduct and maybe say, oh, this could hint at a slightly lower or slightly higher share, things like that. So let's do one worked example together, just to make things a bit clearer again. Let's say that Sam and Alex are in a long-term relationship, and a couple of years ago in 2018, Sam bought a house in his sole name, and this was for £300,000. So only his name does appear on the title, and he's the one that's protected as a legal owner. Okay. However, actually, Alex paid £20,000 towards the deposit, so that's a clear contribution. And she also gave up her rented flat because Sam always told her, this will always be our home together, we can stay in this house, we can live here, maybe raise children someday, and so on. And Alex, she was like, yeah, I'm really happy with this. I believe in our relationship. So for the next 5 years, she paid all the household bills, she paid all the food, she paid electricity, water, and so on. Whereas Sam, he just paid all the mortgage installments, so the direct contributions to the house itself. And Alex wasn't involved in those direct payments at all. Now, if we look at those routes, what can we actually discover? For the first route about agreement and detrimental reliance, we can definitely see that there's been an agreement because Sam promised her before she moved in that this would always be their family home. And Alex gave up her own flat, she paid all the bills, she paid for the food, and this contribution allowed Sam to then focus on the mortgage. And we can recognize that Alex did help a lot with all of those things. It wasn't just something out of love, but it was so that she could live in the property together with her partner, and they could manage all their payments that were due and so on. So we could definitely say that very likely there's going to be a constructive trust. and that Alex would get a beneficial interest because she relied on on Sam's promise. She definitely believed that they would be living there forever, and she gave up her flat, for example. Okay, so this would secure her some protection and equity, so she could get a certain beneficial interest. How big this interest is going to be will obviously depend on lots of different factors. So now, secondly, let's have a look at route B. Did Alex make a direct financial contribution to the purchase price or the mortgage? Yes, because she helped with the £20,000 towards the deposit. Okay, so payments towards a deposit, they will count as a direct financial contribution, and they themselves could also create a constructive trust. Other things like helping with the food, for example, or helping with bills, helping with decoration, they wouldn't count towards a direct contribution, but the deposit certainly does. So we can kind of take from those contributions that there was always some kind of common intention that they would live there forever and make it their home. Okay, so also under the second route, we can see that Alex would probably get a little bit of a protection. Now, those are the two ways we use to historically look at that. So it's fairly limited. Modern law now, under cases like Stack and Dowden or Jones and Kernot, looks at things even beyond those kind of financial contributions and so on. So it would look at the whole relationship, all those years, 7 years they've been living together, the amount of bills each person paid, the promises that were being made, how they actually lived their relationship, did they really share everything, or I don't know, did they each have like separate bank accounts? All of those things are things that can be factored in, and based on those, all of those little circumstances, little additional aspects, we can then see whether we want to upgrade or downgrade Alex's share. So at the moment, based on the deposit alone, for example, the starting point would just be 6.7% because she paid £20,000 towards the 300,000 overall purchase price. But then if we look at all the other circumstances, we can decide, oh, we want to actually go up or down from that starting point. So maybe we could say, well, she's been paying for the food and the bids, so we could raise her share up to like 25% or even more. And we can recognize that she gave up her own flat, all of those kind of things. So additional questions that you might want to ask under the modern approach that go beyond those original thoughts by Lord Bridge is like looking at anything they might have intended. Maybe they've had conversation about who gets which share. Maybe there were some non-financial contributions like childcare. We have a look at how they even ran all their lives. Like, as I said, like, for example, did they have a shared bank account? Who managed what? Who was responsible for doing all the housekeeping and so on. So this is a really big part of what it means to be a lawyer in land law. So if there's co-owners who are sharing a property, but then they have an argument, one person wants to sell, the other one doesn't, or don't really agree on who gets which amount of money. All of those things can then be settled in court and would require a solicitor to look at those aspects. And what are things that you should look at? Why was the property bought? Was it a family home? Was it just an investment? Was it for business reasons? Was it a home where you raised your children together? What are any kind of creditors? Is there a mortgage? Did you have a loan by the bank? What are the interests of those creditors? What are the interests of people who are living there? All of those things are really important. So let's just summarize what we've learned so far in this lesson. The main things you should remember is reciting trusts are based purely on paying towards the purchase price, and very often this will be business property. Okay, so that should be quite easy to calculate. If you pay 10% towards the overall purchase price, then you will very likely get a 10% share as well. With a constructive trust, this is now a bit more complex because there's different routes, so either the agreement and reliance route or the conduct and direct contributions route, and then we've got loads of other aspects that the courts might consider, and it's not just a straightforward calculation, but can take quite some time to work out what would be fair to award in each case. And obviously it's not only about the parties involved, not only about the people who live there, but it could also be about any kind of creditors or other people who have an interest in the property. So I would just give you a little bit of a homework or practice to do. So all I want you to do is to decide which one of the routes that Lord Bridge formulated would apply in this scenario. So the scenario is that Jamie originally buys a flat in their own name, their sole name, only Jamie's name is on the title. But then Taylor moves on in a couple of years later, and Jamie says very clearly, don't worry, this is your home too. Mi casa is su casa, for example. What's mine is yours. And so Taylor gives up their council tenancy and makes some contributions, but only like smaller contributions, really, like with the decoration, renovation, paying for some new furniture they need now that they both live in there. But Taylor never makes any extra major contributions in terms of a deposit or mortgage. So just think about this, work out which route would apply and whether we can create a constructive trust or not. And then just put your ideas in the comments, and then I can let you know whether your thoughts have been correct or not.